been 10 years since I've done this. I think Mayor Alpert, it was her first year on the commission when Laurel Park, in fact, appealed a planning board decision to the city commission involving the Women's Exchange. I think I had been president of Laurel Park and a resident of, sorry, I think I was a resident of Laurel Park for about 10 minutes. And Kate Lohman, who was a longtime neighborhood president, wrote me in and said, hey, you're going to be president. So I quickly learned what a zoning code was. And since then, you know, I have not actually objected to any development in the city, except this one. And the reason I brought it forward today, the reason I'm here, is I am affected more than most, but this decision was an error. I'm not sure how to use the overhead. Should it be there? Okay. And I'm the only one who noticed it in time, so that's why I'm here. But we're all aggrieved. The city is aggrieved. This really was, I believe, a mistake, so I want to outline why I've come to believe that. My basic rationale for the appeal is that on its face, the site plan violates the city's grand tree ordinance. It's taking away 7 healthy grand trees that are live oaks. And the language in the city's ordinance is crystal clear. You cannot remove a healthy grand live oak from private or public property unless certain very specific conditions are met. And those conditions do not apply to these trees. So I saw that when I read the site plan before the planning board approval, and that was the first time the public had any way of weighing in on this project. So I knew it didn't meet the grand tree ordinance, and then the more I dug into it, it really doesn't meet the compatibility standards to grow in a way that complements the neighborhood for botanical gardens. And more importantly, it doesn't meet the city comprehensive plan, which has very specific and quantitative guidelines for canopy coverage and grand tree protection. So if on its face, this plan doesn't meet the city's code, how did it ever get approved? Why are we here? And as far as I can tell, it was a mistake. There was staff turnover in the key position of senior arborist between the time the DRC reviewed this in April and it made its way to the planning board in August. And in fairness to the planning board, they were never given the senior arborist report. The only reason I know about it, the only reason you're going to know about it, is a neighbor of mine who used to work at Selby and knows these trees well did a Freedom of Information request to ask for all documents related to this particular site plan, and it surfaced among them. And I'm not saying anybody did anything wrong. I'm just saying when you lose staff, you lose knowledge. And that knowledge that this plan didn't follow the grand tree ordinance was lost when Donald Olam left the city's employment. So this is a mistake. And your zoning code and state statute provides this process to address these mistakes. As your city attorney just outlined, you could have brought this forward. You as the city commission, as affected parties. The planning board could have. I guess the city writ large, whatever, could have. But I'm the only one who did. So I have this extra burden of proving that if these 102 trees and 7 grand trees are removed, it's going to harm me more than the other 57,000 people who live here, and I think I can do that. But what I really want to focus on is the reason I'm doing it isn't to make trouble for Selby, isn't to say don't make a great new conservatory for all these exotic plants. It's to say you can do better, and this particular plan doesn't meet the city code, and you need to follow it. So I'm following the process you've laid out to do that. Okay. As I outlined, the aggrieved party really is you. It's a highlight of the section of Donald Olam's report that was never actually included in the packet. He read aloud from it at the April 2nd DRC meeting, but it wasn't even in the backup there. And then the conversation between Donald Olam and Selby's representatives on April 2nd was, we're going to go talk about this because this plan as presented does not meet the grand tree protections. You're required to build around grand trees, not through them. And then he left, and like I said, it just seems like it fell through the cracks. Okay. Next up here. So I'm sure Joe can explain this better, but I took my understanding of it from reading the Florida state statute. In my mental model of this, you're an affected person before the development decision occurs. And then once somebody gives the green light, whether that's administrative review or it's planning board or in some cases it's city commission, if you disagree with the decision that kind of terminus body had, the next recourse for you is to go up to the next higher body of the food chain, and that's you all. But I believe that you have to meet 5 criteria for aggrieved party status. The first 3 are identical, in my understanding, to affected person. That is proximity. You've got to live nearby or work nearby the property where the development's going to occur. Second, you have to suffer some harm, either to environment or aesthetics or property value as a result of what that other project is going to do. Third, you have to have participated in the public process through letters or public comments. And those are the things for affected persons, sorry. And then once you get to that decision point, which happened when the planning board approved this, then you have to, if you file for aggrievement, you have to say, hey, the thing I'm objecting to is something that you as a city are guaranteeing to me as a resident as part of the city's comprehensive plan. And that can be something related to health, safety, environment, natural resources, all of which are covered in our comp plan. And then finally, even though the damage, the harm, is going to apply to all of us if 102 trees, 7 of which are grand, go, I have to be in a position where it's going to harm me more, again, because of my proximity or my habits, or I'm a nearby worker or property owner. It's got to harm me more than everybody else. So I think I can show that it will, because they talk about stomping grounds, or at least we did when I was in New York, but these are my paddling grounds. This is my neighborhood. Pretty much every morning for the last 5 years, you can find me rolling my kayak down the Mert, across Osprey, over to Ohio Place, where my sister-in-law used to live, and my former neighbor, who's a realtor in Laurel Park and has probably sold almost every one of the houses there at some point. She lived on Ohio Place. And one of the reasons that people move there is its proximity to that kayak launch, the ability to have walkability to great, vibrant downtown, leafy trees, because we still have canopy there, interesting architecture, and a straight-out path to the bay is the real appeal of Laurel Park. That's one of the reasons it's always been billed as, even by Duane, as like the quintessential walkable neighborhood. And the elements that make it walkable and paddleable include the ability to roll your kayak down the Mert. Where else can that happen? And it's not just that I have proximity to the water and out to Selby and out to the island that I call Kellican Island. I know the habits of every bird that we see every morning. I can tell you which days I spotted which manatees. Yesterday we saw 3 spoonbills. There's only been 1, so that's a new development. It's not just that we have existing flora and fauna that call Selby home. It's that it's a migratory bird path. There were something like 300,000 birds that flew over Sarasota last week. They need someplace to rest, particularly in an urban landscape. And then I remember Canopy Meg, when she ran Selby, she used to talk about oak trees in particular as being condos for critters. She said there were over 2,000 forms of life that call an oak tree home. So that's really why I'm here today, because they can't speak for themselves, and because I can. And if we lose that canopy, they're going to lose their home. I'm going to lose the natural beauty and the ability to take photographs of wildlife. And I even won a contest at Selby once for bird photos. Okay, so that's the greater harm. And then public participation. I've certainly been a vocal advocate for keeping these trees. I did write to all of you and to the planning board and to the press and to Selby's management before the planning board rendered its decision. Once I read the backup and I said, wait a minute, this doesn't follow the plan. I raised that flag then. After the planning board decided, without the benefit of the competent, substantial evidence from the city's own experts, after they made the wrong decision, I wrote to the Herald Tribune and published a letter to the editor outlining the specific quantitative targets that the city has set for canopy coverage and the requirements of the Grand Tree Ordinance, and said, wait a minute, rethink this, because you can solve this a lot of different ways and you don't have to take down these trees. I've continued my public education efforts through posting on social media. I launched a website at keepcanopy.com. I created a neighborhood petition. I developed an interactive video game which was meant as a lighthearted way to illustrate a very serious consequence when you destroy habitat. I've given press interviews and I've run ads. So I've certainly been active in trying to educate. Going back to the legal elements of how this will harm me, if we look at the city plan, this is a comprehensive plan, and I mentioned neighborhoods earlier because I just reread the neighborhood chapter. I didn't count, but it would be interesting to do a word count of the number of times compatibility is mentioned and quality of life is mentioned, and a guarantee is made to we as residents that you're going to do everything you can to keep us healthy, keep the city livable, maintain a high quality of life for all residents, keep us safe, develop interesting and efficient transportation networks, including waterways, and protect and preserve the things that drove all of us to choose this to be home in the first place. The aesthetics and the natural resources, the ambiance. Then there's the environmental chapter, and that's where you start to get quantitative rather than qualitative. You all recognize, and your predecessors have, how important protecting our natural environment is, given how vulnerable we are to climate change and to hurricanes. So oak trees are about the best you can have in terms of tolerating flooding, absorbing runoff, protecting us from storm surge. They're the best infrastructure imaginable, and the city made a commitment decades ago to keep that canopy for that reason. Not all trees, but these specific trees. They set a canopy coverage goal of 40% citywide. Last time you got a report on it was last May, and we were at 31% as an overall average, and the downtown zones were at 15 to 20% due to all the development. And then we got hit with the hurricanes. I don't even want to know what it is now, but I don't think it's exaggerating to say we have a canopy crisis. Now we get to the zoning code. And this code was crafted with Selby's input. I remember them working on the language. It was important to everyone that as that garden grew from a green space to more of an event center, that it grow in a way that kept its compatibility with the surrounding neighborhoods. So they even wrote right into the code, sensitive and coherent matter which preserves the quality of life and integrity of the surrounding neighborhoods. If I lose those trees and we lose that habitat, my quality of life is going to be diminished. And then last, I just wanted to flag, this is more a substantive argument, not for a standing one, but I think there was a real disconnect in terms of what the phrase botanic garden display area means. It's in the mitigation section, and it was, when it was discussed, it was about whether they would have to pay the same way anybody else would if they were removing plants. But the whole concept is sort of left over from, you can see pieces in the code where there's talk of nurseries, and nurseries having outdoor display spaces. And the only place in the city code that display area is defined is with regard to retail. And this is about removing trees, not taking them down. So my best guess, not having been here 30 years ago when they wrote this, is that the intention was to allow people to sell potted palms if you're a nursery without having to get a permit to remove the plant or to pay a mitigation fee. And in Selby's documents, they even talk about the display area as pertaining to mitigation when they give you their tree inventory. And then I'll just close by flagging. There's few absolutes in life, but the third bullet here is why I've brought this forward. It's not debatable. The Grand Tree Ordinance prohibits removal of healthy grand trees from private or public property unless specific criteria were met. Now, a lot of trees were taken out, and maybe some were grand in Phase 1 of Selby, but that was for a garage that had to be proximate to a road. They don't need to do that here. As a matter of fact, and I'd like just one more minute if you could, because I think it's important. Is that okay?
Very quickly.
Okay. If you look in the map in the upper right corner, that's a representation of Selby's current site plan. All the little green spots are grand trees. A lot of the ones that are slated to go aren't even in the footprint of that structure. And they're really only replacing, if you do the math, the new conservatory under air will only be 2,100 square feet more than the current undercover. So one solution would be move those plants off site for a year while you build and reorient the greenhouse. But it's not up to me to solve it. I just want to flag that with 15 acres and only 2,100 square feet, there's a lot of ways to solve that problem without violating the Grand Tree Ordinance.
Thank you.
Thank you.